Good afternoon. My name is Felicia Orth, Hearing Officer in EIB 21-27. This is a rulemaking before the Environmental Improvement Board related to ozone precursors. We are on the final day of our hearing, day 10, and we have reached the 1 p.m. public comment period. Public comment is taken under oath, is taken by audio, not video, and is limited to 5 minutes. Many of you reached out to the board administrator with your names, and I will call on you first. If you're on the platform and did not reach out to the administrator, I'm happy to accept your comment. Just reach out in the chat, which is enabled for everyone. Let's start with Larry Scott. Representative Scott, can you hear me?
Yes, I can. Can you hear me?
Yes, I hear you clearly. If you would please spell your name for the transcript.
I am State Representative Larry Scott. That's Larry Scott.
Thank you, and raise your right hand. Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 5 minutes now.
My comment would be, in addition to my night job, if you will, as a state representative, my job is as a small independent production company located in Hobbs, New Mexico, and have operated exclusively in Lee and Eddy counties for the past 40 years. I have seen the Environment Department estimates of the cost of compliance of $350 million if this rule is enacted as proposed. And I believe that this grossly underestimates the true cost because it does not take into consideration over 100,000 barrels a day of low volume oil well production that will be placed at risk as a consequence. Now, in recent years, I have had difficulty getting low volume gas production connected to midstream gathering systems because those folks do not consider keeping a meter and pipeline available to low volume leases economic, so that there is a charge associated with being able to keep your gas connected to a sales line. In addition to that charge, there would be a substantial investment required for equipment to recover these very low volumes of gas that are vented from stock tanks. And there is no economic benefit whatsoever that can accrue to the installation of this equipment. It will just be the investment required there would never be recovered. So the consequence, and I'm one of the people that will be directly impacted. I have already prepared notices to plug and abandon one of the wells that would be directly impacted as a consequence of this. The little well makes about 4 barrels a day. There is no gas connection available, and it's going to be plugged. There are thousands of wells in this similar situation that will be similarly impacted. I urge the folks considering adoption of this rule to reconsider. A reasonable cost for equivalent CO2 emissions I've read is in the $30 to $50 a ton range. I do not believe that that analysis has been fully applied or implemented to this rule, and I would urge all of the folks that have this under consideration to go through that process before making a final decision. Thank you very much for listening, and that's all I had.
Thank you very much, Representative Scott. We'll move to Mara Yarbrough. Ms. Yarbrough, can you hear me?
Yes, I'm here. Can you hear me?
Yes, I can. Would you spell your name for the transcript, please?
Yes, ma'am. My first name is Mara, M-A-R-A, and my last name is Yarbrough, Y-A-R-B-R-O-U-G-H.
Thank you. And if you raise your right hand, do you swear or affirm to tell the truth?
Yes, I do.
Thank you. I'll start your 5 minutes now.
Thank you, Madam Hearing Officer and members of the Environmental Improvement Board for this opportunity to comment today on the proposed ozone precursor rule. My name is Mara Yarbrough. I live in Rio Arriba County, which is where I was raised and where I raised my own children. In addition to being a mom, I was an elementary school teacher for over a decade, and I'm currently involved with a diverse range of organizations that work on issues related to oil and gas in southeastern New Mexico. Thank you to NMED for your support of both auto gauging and the proximity proposal put forth by clean air advocates. While I appreciate NMED's proposed rule, this rule can still be stronger and in fact must be stronger to truly protect New Mexicans from health harms. The EIB has the authority and a duty to apply principles of environmental justice in its decision-making. In holding to these principles, the EIB must achieve the fair treatment and meaningful involvement of all New Mexicans. Many voices have been heard through testimony and public comment over these past 2 weeks, calling for strong rules to protect the health of our communities. And it is up to the EIB to render this public involvement meaningful by actually hearing and acting upon what people have urged. You can do this by approving stringent ozone precursor rules as recommended by much, if not most, of the testimony and public feedback you have heard. You should also aim to achieve the fair treatment of all New Mexicans, and in particular, of those people and communities who live in close proximity to oil and gas operations. You've heard testimony and comments that a large percentage of folks who live in close proximity to these operations are rural, low-income communities and communities of color. And these frontline communities, along with especially vulnerable populations of children and the elderly, already suffer disparate and cumulative impacts from pollution. A weak ozone precursor rule would only worsen health outcomes for these vulnerable populations. The EIB can prevent additional health harms with strong ozone precursor rules by requiring more frequent inspections for leak detection and repair, by improving pollution control during well completion, by implementing stronger requirements to cut pollution from pneumatic controllers, and by tightening NOx limits from engines along the lines recommended by the National Park Service and clean air advocates. New Mexicans are looking to you to be courageous in your decision-making and to approve rules that put the health and well-being of New Mexicans first. We're counting on you. I appreciate your time and your hard work, and I thank you again for this opportunity to speak today.
Thank you, Ms. Yarbrough. Go then to Judith Gabriel. Ms. Gabriel, can you hear me?
I can hear you, and unfortunately my camera's not working. Is that okay?
We don't take video, so it's just
Okay.
right. Thank you. Would you spell your name for the transcript, please?
Judith Gabriele.
Thank you, and raise your right hand. Do you swear or affirm to tell the truth?
I do.
Thank you so much. I'll start your 5 minutes now.
My name is Judith Gabriel, and I live in Santa Fe. I'm a retired public health professional and longtime member of the New Mexico Public Health Association. I'd like to share some facts that I'm sure you're well aware of and that bear repeating. More than 130,000 New Mexicans live within a half mile of oil and gas development. Oil and gas operations in New Mexico emit 337,500 tons of smog-forming volatile organic compounds and more than 1.1 million metric tons of methane pollution, a powerful greenhouse gas. Leaks due to equipment malfunction and lack of maintenance account for about 70% of the oil and gas industry's emissions statewide. Children, older people, and communities of color are impacted most by these emissions. These inequities should be of great concern to all of us. I'm pleased that New Mexico is addressing methane and ozone through the regulatory process and would like to see the rules strengthened with 3 critical additions. Protect those living closest to development by requiring more frequent inspections to find and fix leaks. Ensure strong requirements for operators to control pollution during the completion of an oil or gas well, as well as when they redevelop an existing well. And finally, strengthen requirements to cut pollution from pneumatic controllers that are used in oil and gas production. The devices are the second largest source of oil and gas methane emissions in New Mexico. NMED should require companies to inspect pneumatics for leaks and accelerate the timeline to retrofit equipment with zero bleed or zero emission pneumatic controllers. With these enhancements, New Mexico's air quality rules can lead the nation in reducing methane and ozone emissions. Please keep all New Mexicans safer from these toxins, especially individuals and communities who are most affected by adding these additions to the final rules. Thank you.
Thank you, Ms. Gabriel. Move then to Caitlin Bryson. Ms. Bryson, can you hear me?
Yes, I can.
I can hear you clearly. If you would spell your name, please.
Okay. Kaitlin. Last name Bryson.
Thank you. If you would raise your right hand, do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 5 minutes now.
Great. Hello, my name is Caitlin Bryson, and I am an environmental artist, activist, and educator living nomadically between New Mexico and California. I recently received my MFA in Art and Ecology at UNM, and my work is centered around environmental justice and earth repair. I want to thank the Environmental Improvement Board for the opportunity to provide comment today. I'm currently working on a bioremediation project and awareness campaign of a fracking flowback spill in Dineta near Counselor, New Mexico from 2019, alongside Beata Sosi Peña and Tewa Women United. This incident, number NCS 19052494442, released 1,400 barrels of fracking flowback fluid and over 300 barrels of crude oil into an ephemeral stream in the Escovado Wash, which is a tributary of the Chaco Wash. The project seeks to bring justice, healing, and political advocacy to this land and its peoples through bio and mycoremediation. These attempts have been enacted in outreach and education through free hands-on workshops and lectures about the potentials of healing through bioremediation, as well as holding community conversations and hearings about policy reformation regarding the handling of future spills. One of the resounding comments we hear from folks during our workshops is that local residents were not informed of this spill until weeks later. Upon talking with more people in and around the fracking leases, we find that this lack of communication about any contamination, ground or air, is nearly ubiquitous. It is commonplace that people living nearby who are most at risk tend to find out last. This injustice has to change, and responsible parties need to be held accountable. Oil and gas pollution are taking a toll on New Mexicans' air, water, and health, but rural communities, tribal communities, children, and the elderly are especially at risk. More than 130,000 New Mexicans live within a half-mile of oil and gas development, including communities of color that face disproportionate impacts from climate change and air pollution. This is certainly what we saw with the incident mentioned above. Leaks due to equipment malfunction and lack of maintenance account for 70% of the oil and gas industry's emissions statewide. I support Governor Michelle Lujan Grissom's call for nation-leading oil and gas pollution rules. To achieve that goal, the Environmental Improvement Board must strengthen the New Mexico Environmental Department's proposed ozone precursor rules to protect those living closest to development. I am encouraged by the fact that leading producers at the federal and state level are standing up to support firm regulations that cut pollution and methane and protect our communities. This includes Occidental Petroleum, the largest acreage holder and one of the top producers in New Mexico's Permian Basin, who has joined forces with public health and environmental advocates in support of even stronger state rules that will protect frontline communities from pollution and ensure New Mexico's regulations lead the nation, which is especially important as the EPA considers federal rules. While NMED has put forward a strong proposal, here are 3 critical improvements that the EIB should make to protect communities and address major sources of pollution. 1, protect those living closest to development by requiring more frequent inspections to find and fix leaks. 2, ensure strong requirements for operations to control pollution during the completion of an oil or gas well as when they redevelop an existing well. And 3, strengthen requirements to cut pollution from pneumatic controllers that are used in oil and gas production. The devices are the second largest source of oil and gas methane emissions in New Mexico. NMED should require companies to inspect pneumatics for leaks and accelerate the timeline to retrofit equipment with zero bleed or zero emission pneumatic controllers. I thank you for hearing me today and for considering these vital policy changes that, if enacted, will have a positive impact on those most vulnerable and the environment at large. Thank you.
Thank you, Ms. Bryson. We're now going to move to Sheila Fox.
Can you hear me?
Oh, Ms. Fox, I've unmuted you. I can hear you. Just be sure to speak up. Would you spell your name for the transcript, please?
Sure. Am I speaking loud enough for you now?
Yes, that's terrific.
Sheila Fox, Sheila, last name Fox.
Thank you. If you would raise your right hand, do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your 5 minutes now.
Thank you. Greetings. I am taking time from my day today to express to you from a deep heart and deep concern. Air pollution from the oil and gas development is such a serious threat to the state of health, not only here in New Mexico, our region, our country, but the globe as well. I'm a grandmother, a mother, a wife, and a healthcare practitioner here in Albuquerque, and I am witness to the breakdown of individuals' respiratory and immune systems, which is then followed by a breakdown of peace of mind, happiness, and mental health as well. I have traveled to pueblos with a veterans clinic that I and 2 colleagues created to treat Native veterans and their families, and I am witness to the health struggles there. It's time overdue to connect the dots to health, climate change, the environment, and the human practices and lack of consciousness that contributes to the toxicity that has grown by gross proportions during my lifetime. The harmful emissions from oil and gas operations disproportionately impacts the children, the elderly, and Native Americans, and those living in rural areas. Our beautiful Native American communities are paying the price dearly, as many live within a half a mile from invasive and harmful well sites that spew oil and gas emissions. I'm sad and embarrassed at the fact that New Mexico is home to some of the worst methane pollution in the country. Methane is a powerful greenhouse gas that is 84 times more potent than carbon dioxide in the short term. This is avoidable. The department's proposed ozone precursor regulations are a good start to address oil and gas equipment leaks and malfunctions, and technology exists today to control leaks, and operators need to be accountable for the pollution they create. When the pandemic created an opportunity for folks to spend more time in nature. And in the beginning, when planes, trains, and automobiles ceased so abruptly, the air pollution cleared. I really noticed a difference in my breathing and the fresh air, which helped my brain to receive more oxygen, and the chronic sinus problems I have were improved. We have solutions to our toxic problems. I really encourage you to check out the movie Fantastic Fungi and Call of the Forest. Very inspiring. Please support the New Mexico Environmental Department rule that ban the practice of routine venting and flaring at new and existing wells. I am hopeful that my embarrassment of our state can turn to pride with the commitment of our governor to lead the nation in methane emissions rule. One of my favorite Yiddish sayings is, "Abi gesund kann man glücklich sein." If you have your health, you can be happy. Thank you for your time and willingness to hear my concerns for myself, my family, and the generations that are inheriting what we are leaving them with. Thank you.
Thank you very much, Ms. Fox. We're going to move to Susan Homer. Ms. Homer, can you hear me?
Yes, I do.
Oh, good. I can hear you. If you would spell your name for the record, please.
It's Susan, S-U-S-A-N, Homer, H-O-M-E-R.
Thank you. And if you would raise your right hand, do you swear or affirm to tell the truth?
I do.
I'll start your 5 minutes now.
Good. I live in Albuquerque, and I wasn't born here, but I've lived here since 1969, over 50 years. I want to thank the EIB for allowing me to comment on the proposed ozone prevention rules. During the years that those 50 years that I've plus 50 years plus that I've been here, I've seen an increase in awareness and understanding of both the dangers and the costs of polluted air for all of us. We know now that New Mexico has some of the worst pollution in the country because of our very leaky oil and gas basins. I've also seen increased knowledge and understanding of what must be done to prevent damaging air pollution. We know what to do to prevent it, and we know how to prevent it. And that's why the EIB's work on these rules is so important. And we thank you for that. The proposed rules before you are strong, but they can be strengthened. Requiring better control of leaks, for example, would decrease methane emissions in the most impacted areas. I understand that New Mexico ED Environmental Department is now supporting increased leak detection and repair in close proximity to residences. So I'm grateful for that. But I keep wondering, who benefits from seeing the proposed protections not put in place? Are there a few people and companies squeezing out extra profits at the expense of all the rest of us? Who benefits when the protections are not put in place? I urge you to set the strongest rules possible for the benefit and protection of all New Mexicans and for all those beyond as well. Thank you.
Thank you, Ms. Homer. All right, let's see. I have two more who signed up to give public comment. Chad Ingram. Not seeing Mr. Ingram by name. I do have one unidentified caller. Caller 16. Who is this? Hello? Okay, I'm not hearing anything from caller 16. And then finally, Preston Miles. Look for Preston Miles. I don't see Preston Miles either. Give caller 16 one more try. Is this Mr. Ingram or Mr. Miles? No. Okay. That is all for, oh, wait. Oh, Ms. Cow, you offered comment earlier today, and public comment is taken just once. See, I think then at this point we can return to the technical case. We had Mr. Smitherman up, and we were about to begin his questioning. Oh, there's Ms. Fox, Mr. Heinzer, and Mr. Smitherman. All right, Ms. Fox, if you would.
Thank you, Madam Hearing Officer. Good afternoon, Mr. Smitherman. Let's see, you heard Mr. Holderman's testimony today in support of the Clean Air Advocates and EDF's, I'll call it the completion proposal, correct?
I'm sorry, I was a little distracted when he was testifying, so I didn't hear all of it.
Did you hear that he testified, or did you read in his written testimony that Oxy believes that the completions proposal is feasible for Oxy to undertake?
I generally remember that.
And it sounded as if from your testimony that you're aware that Clean Air Advocates and EDF amended the original language we proposed in our initial direct filing at the request of Oxy to delete the vapor tight language in our completions proposal. You're aware of that, correct?
Yes, I am.
And that was deleted out of safety concerns, correct?
I understand that, yes.
And then it sounds like this morning you heard Mr. Alexander's testimony in support of Clean Air Advocates and EDF's completion proposal, correct?
And again, I heard much of his testimony. I didn't hear all of it.
Did you understand that Mr. Alexander was actually a completions manager for Southwestern Energy for a time?
Yes, we basically held similar roles at different companies.
What are the responsibilities of a completions manager?
Well, I don't know what his responsibilities were particularly.
In general?
My responsibilities at the time were overseeing all operations, which included drilling and completion and normal production operations.
And then you heard that Mr. Alexander was also served as Vice President of Health, Safety, and Environment at Southwestern Energy for 4 years.
I did hear that.
And did you hear his testimony that our completions proposal is technically feasible and cost effective?
I did. I don't agree with that.
And
I think that, may I finish? I think that might have been in context, maybe in a different context. But when you look at the OCD rule requirements now in New Mexico, the amount of gas that is, in essence, not captured during the initial flowback is a very, very small amount, and it makes these costs not cost effective.
And you understand that the Clean Air Advocates and EDF's completions proposal is taken nearly verbatim from a rule that the Colorado Air Pollution Control Commission passed last year, correct?
I understand it generally. I'm not an expert on those particular rules.
Do you have some familiarity with that Colorado rule on completions?
Only basically in context of discussions during this rulemaking process. I was not involved in the Colorado rulemaking process itself. And so a lot of those maybe fine points were discussed during that process, but they didn't come up in conversations or in our research.
I'm gonna, if Madam Hearing Officer, if you could give me screen sharing privileges, please. Mr. Smitherman, I'm gonna pull up what is Clean Air Advocates Exhibit 19, which is that Colorado rule, which is under what's often referred to as Colorado Regulation 7, which you might be familiar with. Hold on one second here. Let me see if this is the right one. Let me get the other one. Hold on one second here. Need to do a little, bring this up first on my full screen, and then I can bring it up for sharing. Okay, so this, Mr. Smitherman, is Clean Air Advocates Exhibit 19. As I said, it's in part of Colorado Regulation 7, which is their completions proposal that we've talked about that was passed last year that became effective May of this year. Just going to scroll through it. Some of these parts that are highlighted are just, parts that are in our proposed rule. And I'm going to scroll down to the statement basis here for the rule. And part of what this rule says, I won't read the entire statement of basis for flowback vessels, but I'm going to read a little bit, which says, starting at about the third sentence in that highlighted paragraph, NSPS Quad OA allows operators to use open vessels to contain flowback fluids and solids, and does not consider a well completion vessel a storage vessel, which means operators are not required to control well completion vessel emissions. Therefore, to build on the NSPS reduced emission completion requirements and further reduce pre-production tank emissions, owners or operators of pre-production operations must use enclosed flowback vessels after the drill out phase, which the Commission recognizes has a high ratio of solids to liquids and route emissions from flowback vessels to air pollution equipment. Stop sharing. So you understand from that the Colorado Air Pollution Control Commission recognizes the high ratio of solids to liquids during pre-production, correct?
Yes.
What in Colorado is the equivalent agency to New Mexico's Oil Conservation Commission?
I don't know. I don't recall.
Are you familiar at all with the Colorado Oil and Gas Conservation Commission?
Yes, now that you reminded me, I remember that. Yes, certainly.
So that would be the agency in Colorado that, is the equivalent of OCC here that you described as, can't remember your exact words this morning, but something to the effect of, that's the agency that knows the ins and outs of oil and gas, something like that, correct?
That's close enough.
I am now going to pull up Clean Air Advocates Exhibit 20. Uh-oh, I did it wrong. Hold on. Okay, I'm going to do this, and then I'm going to do this. Are you at all familiar with the Colorado Oil and Gas Commission's recently promulgated rule on completions?
Not in specificity.
Are you aware that the Colorado Oil and Gas Commission adopted the Colorado Air Pollution Control Commission's rule on completions that we've been talking about?
Ask the question again, please.
Are you aware of the fact that the Colorado Oil and Gas Commission also adopted the completions provisions that the Colorado Air Pollution Commission adopted?
I'm not familiar with that. And of course, the circumstances in Colorado may be different. And I know the OCD considered their knowledge of the industry when looking at the EDF suggestions in last January's hearing, when they decided to not require this same type of flowback closed vessel motif, if you will, on New Mexico operators. When they have the established regulations that require, once separation flowback is technically feasible, that those gases would be sent to, and generally sent to sales. There are a couple of exceptions for safety and for pipeline quality issues. But I think that they've recognized that, and they also had these rules in place at the time, as I recall.
So then, as I understand it, you were not aware that the Colorado Oil and Gas Commission adopted the completions proposal that Clean Air Advocates and EDF are putting forward. Is that my understanding?
I think that that's correct.
Now there was testimony, and then so you're not aware of when that rule went in effect?
No, ma'am.
Okay, thank you. There was testimony from Mr. Alexander this morning that I believe you heard, that because you referenced it, that EDF had communicated with the Colorado Air Pollution Control Commission and inquired whether they had experienced any problems with implementing their completions provision, correct? You heard that testimony this morning?
I think I heard that, yes.
And then I also take it from what you said that you did not do any due diligence with either the Colorado Air Pollution Control Commission or the Colorado Oil and Gas Commission to find out if either of those agencies had experienced any problems with implementing the completions provisions that they adopted. Is that correct?
Well, no, I did not, because, I mean, and let's also keep in mind that these rules have been in place a really short time in Colorado. And so the issues that I'm concerned about, they may lead to rare incidents, but it doesn't mean that they're fundamentally safe. So it may take time before an incident shows up and causes problems.
And were you aware that the Colorado Oil and Gas Commission rule on completions went into effect in January of this year?
Generally.
Okay. Thank you very much, Mr. Smitherman. That's all I have, Madam Hearing Officer.
Thank you, Ms. Fox. Any other parties with questions of Mr. Smitherman? Please turn on your camera. Not seeing anyone. We'll turn then to the board for their questions. While I'm doing that, if you're an attendee on this platform, please reach out through chat. Madam Chair.
Madam Hearing Officer, I don't have any questions. Thank you.
Thank you. Vice Chair Trujillo Davis.
Yes, I just have one clarifying question. Mr. Smitherman, did I understand correctly that you were saying that EDF's proposed language for completions was duplicative of the OCD's recent rule that they passed in January?
I don't think it's duplicative. I think that they go beyond what the OCD requires. In essence, the OCD in their structure, their regulations have, in essence, squeezed down the period of time that operators are allowed to, in essence, vent gas down to a very, very small period of time. And therefore, in essence, a very, very small volume of gas. Because once a well is flowing back with enough gas and enough pressure to allow a separator to work, you move out of that initial flowback stage and into separation flowback stage, in which the OCD requires that gas be flared, or really for the most part sold. It's supposed to go to production vessels and be sold, but there is a provision if there's a safety issue related to that, that you're allowed to flare it. And another possible exception is if your gas does not meet pipeline specs at that point, again, you're allowed to flare it, not vent it. So what they've done is, in essence, almost eliminated the volumes of gas that, in essence, EDF's proposals would target. And the costs and the complexities and the risks involved in that, in my view, don't warrant their suggested requirements.
Oh, okay. I believe I understand now. So if we were to consider putting it in the current rule that we're evaluating, then it would be we would have some duplicate. I am sorry, it's the last day of this hearing and I have very little words left. I've used a lot too. So if we looked at their language for this current rule, we could be kind of duplicating some of the requirements in the OCD rule and this NMED rule.
I'm going to still say not duplicating, because what their requirements would do would be add on additional requirements just during the initial flowback period, where the OCD does not have requirements for capture. And we believe that the volumes of gas during that time, because of how the OCD has structured their regulations, are very small and do not warrant the risks and the costs associated with trying to capture them.
Okay, I understand. And thank you for your patience in explaining that.
Certainly.
And I also wanted to note, I'm very sorry for the loss of that young man that you mentioned earlier. Deaths in the oil field hit very, very hard. So very sorry about that. And thank you for taking the time to clarify some of these issues.
Thank you, ma'am.
Member Cates? No, I saw him on the platform. Member
No
Bitzer?
questions here. I'm sorry, no questions here. Thank you.
Oh, thank you, Member Cates. Member Bitzer?
Madam Chair, I'm sorry, Madam Hearing Officer, I have no questions. Thank you.
Thank you. Member Garcia?
Yes, thank you. I have a question. Mr. Smitherman, your testimony reminded me that yesterday Mr. McCabe mentioned that there was a NIOSH, National Institute of Occupational Safety and Health alert about measuring fluids. And I'm wondering, do you know if there is a NIOSH health alert associated with this problem you're concerned about?
I'm not familiar with that. It wouldn't surprise me to find that API has opined on the general topic of static electricity building up with fluids, moving fluids. But I don't know of any that address this particular set of circumstances.
Member Honker?
No questions, thank you.
Thank you. Mr. Heinzer, will there be any redirect?
Madam Hearing Officer, I don't believe that we do.
All right, thank you so much, Mr. Smitherman, for. Oh,
Madam Hearing
sorry,
Officer,
Madam
one more
Chair.
question.
Okay.
Thank you again, Mr. Smitherman, for your presentation and also all the slides that go along with the presentation. It makes it really easy for us to follow what you're saying. But with that, I just had one more clarification to follow up on Vice Chair Trujillo Davis's question or comment. So I just wasn't, I was a little confused. So did that individual, that wasn't on on this process that we're talking about, that death of that individual, it was on a different type of process or type of situation. Is that correct?
That's correct. I described two incidents, one of which was very, very much directly related to this process. And we got lucky that no one was hurt when that incident occurred. The exact same concept where static electricity set off an explosion in a flowback vessel. The other incident was related to a different technique, but it really points to the idea that you can have incident-free use of a technique for long periods of time. If it's still fundamentally unsafe, at some point, the stars are going to line up against you and you're going to have a problem. And that's what I'm concerned about here, is that maybe there's some operators that understand this fully and take proper measures, but there's a lot of operators out there, and maybe some of them are not plugged in and understand these details of the physical nature of the risk, and they don't take those precautions, and we're going to end up hurting or killing someone. That's my concern.
So, and thank you for that added information. So are you saying that there are there's companies out there that don't do this or take this added measure because of the safety concerns?
Well, let me try to address that maybe a little bit differently. What we're trying to, the point I think that I'm trying to make is that we're looking at the possibility of putting a requirement in place in New Mexico. And I look at that and I want to balance the risks versus the rewards. And the rewards are capturing the gases that would escape. But as I've mentioned, the very, very small amounts of gas because of how the OCD has structured their regulations. So that small benefit is then balanced by the cost to capture those gases and also the inherent risk that go with that. And we just don't believe that the reward is worth the risk. Does that make sense?
That makes sense. I guess I was just going back to some of the information and some of your statements in that it seemed to imply that companies are not doing this because of those safety risks. And so I was just wondering, because we heard a little bit of different testimony and commentary throughout this hearing. So I'm just trying to reconcile that. So are companies doing this still?
I think that there's companies that are, capturing, well, let me say it differently. I didn't do a poll of lots and lots of companies to understand which ones already are doing some of these techniques and which ones are not. So I really can't necessarily opine on that. I'm really focusing on what is going to come from these rules and the requirements that are going to come from here. If it's required, then all operators will have to do it. And that in essence says, well, I'm now going to put this technique in many, we're going to repeat this technique many, many times in New Mexico. And then if those companies aren't doing it with all those risk mitigations in place, you're causing a risk opportunity.
Thank you for, I guess, clarifying how your explanation is and some of your testimony is focused on, and not necessarily on the I guess that companies are doing this. I think there must be some, right? Because Colorado has this rule already in
Right.
place. So there must be some companies doing this, right?
Exactly. And
Okay.
if those companies are taking all the proper measures, then they've at least mitigated that risk part of it. But again, there's the other part, that's the cost versus the benefit. With OCD's regulations driving those volumes down because the initial flowback period is getting so short that it just doesn't, the risk, the costs don't offset the benefit.
Oh, thank you for that added explanation, because I was just wondering and a little bit confused on how an adjacent jurisdiction in the state of Colorado was making companies do this if it was unsafe. But so what you're saying is because of the OCD rules, then that makes it a little bit more, not less safe, but that there's that shorter time frame or shorter period or shorter in your graph there, that these rules would then maybe address, but there's that cost. Is that correct? Am I framing it that
That is correct. And I'm certainly not blaming the Colorado regulators for doing something that intentionally puts people at risk. I am concerned that perhaps this was not vetted as well as it should have been. And I'm also concerned that operators in Colorado, which have to do this process, may not understand the physics associated with it and may not understand how to mitigate those risks. Colorado may be very thoughtful in their process, but an individual operator must know how to mitigate risk.
Objection, speculation. Madam Hearing Officer.
Ms. Fox?
Objection, speculation. All of this, he testified he didn't know about the Colorado process. He doesn't know about Colorado operators. This is all speculation.
All right. Mr. Smitherman, I'd like you to answer without speculating, based on your own personal experience and knowledge of the rules.
Certainly. Let me try again without naming Colorado. Any regulatory body can put rules out. And if my experience is if operators don't really understand the risks involved in particular techniques, that they can cause problems. In fact, I'll use the incident that killed that young man on our location. Now, that was not required, didn't have a requirement under the regulations, but operators tend to not understand the physics of that particular technique. And quite frankly, all of the service providers that provide that service, I have not run into one that fully understands the risks there. So what I'm saying to you is, if there are fundamental risks involved in a process, you need to be careful about them. And if you're requiring, if New Mexico requires a process, we need to make sure that operators are fully aware of the risks that are involved in that. I don't believe that it is worth putting these risks in place in New Mexico because the volume of gas that we're going to capture is so small.
Thank you for that response, Mr. Smitherman, and I apologize if I took us down a rabbit hole and got us off track there.
I thought it was a good question.
Thank you.
Thank you, Madam Chair. And Mr. Smitherman, is there any reason not to excuse Mr. Smitherman at this point?
None for me, Madam Hearing Officer.
All right, thank you, Mr. Heinzer. Thank you again, Mr. Smitherman. We are going to turn now to Ms. Witherspoon. Leslie Witherspoon, who entered an appearance as a party on behalf of Solar Turbines. I see you on screen, Ms. Witherspoon.
Hi.
Hi, would you spell your name, please, for the transcript?
Sure. Leslie Witherspoon, Leslie Witherspoon.
Thank you, and raise your right hand. Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead.
Okay, good afternoon, and thank you, Madam Hearing Officer, Madam Chair, and board members. I am not a lawyer, and everything's been very formal and lawyerly, so I apologize for anything I might not do process-wise. I work for Solar Turbines, but I will try to follow the format everyone else has here who has testified. I work for Solar Turbines, and I have for over 23 years as the environmental program manager. And in this capacity, it's my responsibility to assist in the development, interpretation, and implementation of air emission regulations around the world. I act as a liaison between our customers and the regulatory community and our engineering folks so that new products and existing product improvements and new regulations are developed with consideration of the environment, technology limitations, cost, efficiency, safety, fuels, all the parameters. I routinely support customers with air emissions data and air permitting strategies in over 100 countries around the world. Though due to the complexity of the US regulatory structure, it consumes the bulk of my efforts. Prior to joining Solar, I worked as an air quality consultant for 7 years, assisting industrial clients with air permitting, dispersion modeling, and regulatory compliance. I have a bachelor's in chemical engineering and an MBA from the University of Kansas. My employer is Solar Turbines, and who is the original equipment manufacturer of many of the units and the turbines that are situated in New Mexico. We have over 16,000 turbines in over 100 countries worldwide. 8,000 or so of those are in the States. And like I said, since 1960, we've sold over 150 of those units that are primarily in oil and gas applications in New Mexico. The reason I wanted the opportunity to submit technical testimony versus just coming in the public comment arena was so that the board and New Mexico Environmental Department had the opportunity to question the actual OEM should any questions arise during the process. Saying that, my need to comment or provide testimony has kind of morphed over the process. I had intended to address several issues in my testimony, but the NMED has done a good job at addressing those concerns through several of the comment letters that I have written and submitted during the process. And in addition to one that was submitted, some comments that were submitted and addressed during this hearing process. So I would like to thank the NMED for addressing stakeholder concerns while drafting a rule for turbines that does reduce emissions from these existing turbines. And we support the changes. Solar supports the changes made to Section 113 as of the September 16th version. And the requested change that we made during the hearing process for one of the minor threshold changes from 4,000 to 4,100 horsepower that allows for all the ratings or all the temperature matches of one of our ratings to be all in the same category. So we appreciate that. There's only really one other comment that I'd like to make that hasn't been addressed, I guess I should say, by NMED, and it was also mentioned by Justin Lasowski, but from NUMOGA with relation to carbon monoxide. Solar has requested in our comments to remove all references to carbon monoxide from the proposed rule in the turbine section, at least. There's a couple sections that I referenced in my comment letter that clearly state that the scope and objective of this rule is to establish emission standards for specific ozone precursors, namely VOCs and nitrogen oxides. Including emission standards for monitoring, record keeping, reporting, testing requirements for carbon monoxide, we don't feel should belong in these rulemakings. And from my experience in working with other ozone standards in other states, their CO is commonly not part of those standards either. So that concludes what I wanted to say today. So I appreciate the time. Thank you very much.
Thank you, Ms. Witherspoon. If you're a party with questions of Ms. Witherspoon, please turn on your camera. Not seeing anyone. I'll turn to the board for their questions. If you're an attendee on the platform with a question, reach out through chat. Madam Chair?
Thank you, Madam Hearing Officer. I don't have any questions at this time.
Okay. Vice Chair Trujillo Davis?
Yes, thank you. I don't have any questions either.
Thank you. Member Cates? Member Bitzer?
I have no questions. Thank you.
Member Garcia?
No questions, thank you.
And Member Honker?
No questions, thank you.
All right. Well, thank you very much, Ms. Witherspoon.
Thank you for the opportunity.
Thank you. I need to go back to Samantha Cow. I had thought she was trying to give public comment twice, which we don't allow given the number of public commenters, but it turns out she had a statement from a different person. Ms. Cow, I've unmuted you. Can you hear me? Ms. Cow? Well, all right. I'll look for Ms. Cow at 5 o'clock then. And anyone, by the way, on the platform, or if you have a friend or colleague who would like to offer comment, we have just one more oral comment period at 5, but written public comments can be submitted to Pam Jones through the end of the day. So thank you. Right. Do I understand correctly that we're going back to the department and that we have no other technical testimony besides the department's wrap-up Suhr rebuttal?
Thank you, Madam Hearing Officer. I believe that's the case, but I don't see anybody else popping up to say otherwise. So if that is indeed the case, I will have Ms. Keene and Mr. Palmer join us. Thank you. All right, so starting with Mr. Palmer. So this is relating to the testimony from yesterday from NMOGA, IPA&M on storage tanks, and Vice Chair Trujillo Davis had asked a question regarding the tanks subject to NSPS subpart KB, and there was a request for the department to provide information regarding those tanks. Can you discuss that information, Mr. Palmer?
Yes. Subpart KB is the NSPS for volatile organic liquid storage vessels, including petroleum liquid storage vessels for which construction, reconstruction, or modification commenced after July 23rd, 1984. And they asked for me to try to provide some numbers from the department's equipment spreadsheets. The equipment spreadsheet for storage tanks includes data for 53 storage tanks that are subject to the NSPS subpart KB. 12 of these storage tanks are at 4 facilities that have major source Title V permits. 11 of these 53 storage tanks have vapor recovery units, and 2 have flares listed as control devices. 3 of the storage tanks have floating roofs or seals listed as controls.
Okay, thank you. And then Ms. Keen, last week, our Madam Chair Sweeney inquired about the number of wells located on tribal land and who is responsible for the regulatory oversight of those wells. Could you provide a summary of the data you've collected?
Yes. We queried OCD's website for wells that are located on tribal lands. There are 2,663 active oil and gas wells located on tribal land. Also, EPA Region 9 implements the Clean Air Act for the Navajo, on behalf of the Navajo Nation. They do have a delegated Title V program at the Navajo Nation through the Navajo Nation EPA, but for minor source permitting, that minor source permitting program is implemented by EPA Region 9. EPA Region 6 has tribal authority or has implementing authority over all remaining tribal public lands within New Mexico. In the event that there's different mineral right owners, BLM may do some inspections in the event that they have very limited oversight on federally owned land within those areas as well, where there's different mineral and surface right owners.
Okay, and let's see, let's move over to NMOGA's proposed revisions to the definition of commencement of operations in the rule. Ms. Keen, what is the department's position on those revisions?
The department is agreeable to revising the definition to more closely align with the Oil Conservation's division of commencement of operation.
And so that would not mean the exact language that Mr. Smitherman was providing, or I guess asking for the department to remove, but you're saying we would align our definition with OCD's definition, correct?
Yeah.
Okay, thank you. And Ms. Keen, can you just state what the department's position is regarding the proposed requirements for flowback vessels and pre-production operations?
Yes, and the department really does not have the technical expertise in this area in order to evaluate the proposal. And so we are not able to take a position on that specific proposal. The department believes the board should decide the issue based on the testimony provided by the other parties.
Thank you. And that is, I believe, all I have for the department's wrap up here.
Okay, thank you. If you are a party with a question, department panel, please turn on your camera. Mr. Heinzer.
Thank you, Madam Hearing Officer. Ms. Keen, it's good to see you this afternoon. And I just wanted to touch briefly, just so we understand sort of where we are on the question of a floating roof tank. This had been raised initially, I think, in NMOGA's attempt to come up with a stabilized definition to address that, in which it was just that perhaps subpart KB might be adequate for those tanks. And then the department seemed a little bit more unsure of its position yesterday or the day before, whenever we last talked about this. They sort of been blended together. I'm just trying to understand what the department's position is on a floating roof tank, whether you believe that the current language in Part 50 is appropriate for those, or if that's an issue that's under advisement, or what you're proposing to do on those.
So we do need to regroup on that. We don't have a, specific answer on whether or not KB subject tanks should also be subject to Part 50 requirements.
Okay.
That was a new issue that came up and we haven't landed on that.
Right. We understand that that's an issue that came up late, and I appreciate your clarification that it's still a little bit up in the air. Thank you very much.
Any other parties with questions of Ms. Keene? Not seeing anyone. I'll turn to the board for their questions. While I'm doing that, if you're an attendee on the platform with a question, please reach out through chat. Madam Chair?
Thank you, Madam Hearing Officer, and thank you, Ms. Keene, for coming back and explaining NMED's position on some of the discussion for today and over the last few days. So I just want to make sure I'm clear. So right now, I think you mentioned a few minutes ago, NMED really doesn't have a technical position regarding some of our discussion today. Is that for the proposed section 127 language?
Madam Chair, that's correct.
Okay, so I was just wondering, and I might have missed it. There's been so much information over the last few days that there wasn't any analysis by NMED on the cost benefit of that language. Is that correct?
Madam Chair, that's correct. That was not the proposal made by NMED, and so we did not provide or prepare any economic or feasibility analysis on that proposal.
Okay, and may I ask if NMED has I don't know if this question is appropriate, but if NMED also heard some of since it was brought up earlier, some of the testimony regarding this under the OCC process earlier this year, and if so, what if anything came from any comments regarding that process?
Madam Hearing Officer, I did not attend that hearing, so I'm not privy to all the discussion that went into it. I think that probably the transcript for that hearing could provide some important information for the board's consideration for this subject.
Okay, well, I appreciate that, Ms. Keene, and I just have a quick follow-up on some of the responses you had for Vice Chair Trujillo Davis. So the some of the wells that you mentioned are on tribal lands. Are most of those on Navajo tribal lands, or are some also on Jicarilla?
Madam Chair, there are 1,950 wells located on Jicarilla and 500 wells located on the Navajo Nation.
Okay. So Jicarilla would fall under EPA Region 6, I think is that
That's correct?
And then you have mentioned that Navajo Nation has a Title V program. Does Jicarilla as well? Do you know?
Madam Chair, I do not believe that Jicarilla has any delegated authority under the Clean Air Act, and so EPA implements the Clean Air Act on behalf of that government.
Okay. And do you know if any of the other tribes or pueblos in New Mexico have treatment as a state or regulate their air quality?
Madam Chair, Santa Ana and Santo Domingo, I believe, both have treatment as state in a very limited manner. I do not believe any of the other pueblo has full I know that no pueblo has full delegation, but a couple of them have very limited partial designation as treatment as state under the Act.
Okay, thank you so much again, Ms. Keene. I appreciate all of the time on this issue and for you following up with Vice Chair Trujillo Davis's question. Thank you.
Vice Chair Trujillo Davis?
I don't have any additional questions. I just want to thank the NMED for taking the time to research the questions we did ask and for having patience with us in all of our questions. So thank you.
Member Kate? Member Bitzer?
Sorry about the delay again. No questions here.
Oh, thank you, Member Cates. Member Bitzer?
Yeah, real quick, following that, following the chair's line of questioning about tribal sovereignty, and do the Navajo Nation government or Jicarilla government receive any royalties from those wells that we know of?
Member Bitzer, the royalties would be associated with the owner of that well. So they'll be the recipient of the royalties. And I can't unfortunately speak to the ownership structure of those assets.
So it could be that there's wells on tribal land and the tribes don't benefit at all.
Member Bitzer, that would depend on the ownership structure, the mineral owners.
Okay. That's all I have, Madam Chair.
Thank you. Member Garcia?
No questions, thank you.
And Member Honker?
One clarifying question on Eldar, if I can raise that. The frequency at which a facility would have to do the leak detection and repair is set out in the rules. Now, will that remain constant as long as the facility is in that category? Or is there, I guess my question is, if they show to be in compliance for several years, is there any change in that frequency that's required, or is that just constant over time?
Member Hunker, these are enduring requirements and ongoing surveillance of equipment and processes that are known to break down and leak. And so continuous maintenance and surveillance of those components is appropriate and for this type of emission source. And there's not a specific off-ramp from these requirements.
Okay. All right. Thanks for that clarification. And thanks for answering all of our questions over the course of this 2 weeks.
Thank you. Any follow-up, Ms. Katz?
No follow-up, and I just would like to just thank the board for just how involved they've been, and it's really been a great experience to see that hasn't always been the case. So thank you so much.
Yeah. Thank you. Thank you so much, Ms. Keene and Ms. Katz.
May I make one more comment? Also, I appreciate all the questions and the interest as well. And there were questions brought up last week about our consultation with tribal entities, and we will provide information on that in our final findings of fact. I just wanted to let you know that we did perform government to government consultation. We did make presentations to the All Pueblo Governors Association, and then did some presentations in Counselor as well. So just to answer that question also, thanks.
Thank you. Let's see. So thank you very much, Ms. Keene and Ms. Katz. Is there anything, any other testimony? We do have a little bit of public comment at 5. But before we get there, I'd like to talk about the post-hearing process when the time is right. Ms. Paranos?
Thank you, Madam Hearing Officer. I think just one more item. So when I initially put on a few of my witnesses before you had ruled on the motions to exclude some of their testimony and exhibits, I did not offer their testimony or exhibits into evidence. So I just wanted to close the loop with this. I believe your instruction was for the attorneys to request that all testimony and exhibits were entered into evidence. So that is my request.
Thank you. So yes, all of EDF's exhibits and the testimony adopted by the witnesses is admitted. We need to get a complete list of the numbers and letters, et cetera, to the court reporter.
Okay, thank you.
So we can tie that up. Mr. Heinzer, I see you on screen.
Yeah, I guess I had a very similar question to Ms. Paranos. We had submitted the revised red lines for the initial NMOGA B and 47, and so those would be in the position of needing to be admitted as well. I believe, I'm not sure about the status of Adam Meyer's exhibit, which was submitted yesterday, our NMOGA exhibit 61. That was the spreadsheet that was put on the screen and discussed and has, to recall the hearing officer's attention, it's the tank issue. And we and Ms. Katz suggested that they would also put in Mr. Palmer's that had a different number. And I think Ms. Katz has submitted that, and I don't remember the number of hers in her most recent email submittal to Ms. Jones. So I think those should probably go in because they were both testified to and addressed by the board with examination questions. And then the question for the hearing officer's preference is we'd submitted NMOGA Exhibit 63, which was our proposal for the department's consideration on automatic tank measurement. There's been some variance between whether those are just filings or if those are exhibits. Do you have a preference whether we leave that as a filing or as an exhibit, just to make it easy to find?
So the pleadings are all part of the record, but not necessarily evidence. So to the extent, I guess that's my instant reaction is if it looks more like evidence, I think it's good to call it an exhibit, mark it and offer it as an exhibit. The board members get all pleadings as well, but
okay, so that would mean that maybe our exhibit 63 and 64 will just leave as filings instead. And then the one that we did is that Mr. Smitherman testified pretty extensively in his direct and covered the issues that were in the original NMOGA red line. And just to make it a little bit cleaner, we thought we should extract what he had adopted out of that original exhibit B and put it just as its own exhibit so that the board didn't have to have recourse to original exhibit B and could just look at what he testified about on that specific section. That means that the comments in the rest of exhibit B aren't constantly back in front of the board. It's just what he talked about on the LDAR issue.
Okay, I guess I thought you'd already remedied that, but Ms. Fox?
Thank you, Madam Hearing Officer. That was my question. I don't understand the need for that exhibit because that is, those LDAR comments have been excluded. And then we went through a pretty careful and detailed analysis the other day about what NMOGA could introduce and that we wouldn't object to, and all those, you know, in Mr. Smitherman's Suhr rebuttal slides, which got a lot of that evidence in. So I guess it was my impression that the evidence on LDAR had come in, and I'm not understanding the need now for the comments that have been struck.
I guess that's my question too, Mr. Heinzer.
So the rationale, Madam Hearing Officer, is that Mr. Smitherman's direct discusses the comments in the NMOGA red line, and you can't really understand his comments without knowing what he's talking about, because he's talking about how things are being done on that other sheet. And so without having that, you're sort of at sea about what it is he's talking about. So this is only his direct, and we agree that on his Suhr rebuttal that those are already in, as you've admitted, with the exception of the couple of issues for proffer. So this is just the original testimony of Mr. Smitherman in his original exhibit A1, NMOGA A1. But it talks about the stuff that's in NMOGA exhibit B. And we were trying to come up with a way to have it so that you could see what he was talking about in his testimony without importing all the other comments in exhibit B into the record in respect to what Ms. Fox had moved and you had previously ruled.
Okay, so To go back just to this concept of striking again, B and 47, they're in the record as you filed them because they were filed, and no one reaches into the record to tear them up um, or anything like that. So I don't know that any further effort there is necessary. I mean, if someone really doesn't understand his direct testimony without going to B and 47, they're there.
Okay. If that's the case, the Madam Hearing Officer, it may not be necessary.
Okay. But I think we still need to admit Exhibit 61. Is that what I understand?
Yes, we would need to exhibit NMOGA Exhibit 61.
Okay.
We already did 58, so I think we're good.
All right. Any objections? No, 61 is admitted. And then Ms. Katz, do you want to give a number to the Palmer information?
Yes, and I guess I probably should just formally move for these exhibits that so Mr. Palmer's, the single tank, sorry, I'm trying to find this. The single NMED single tank cost estimate is marked as NMED rebuttal exhibit 29. And then I sent around, NMED rebuttal exhibit 26 is the updated turbines reductions in costs for NOx spreadsheet. NMED rebuttal exhibit 27 is updated heaters reductions in costs NOx spreadsheet. NMED rebuttal exhibit 28 is the updated storage tanks reductions in costs BOC spreadsheet. NMED rebuttal exhibit 25, sorry, these are out of order, is the updated ICE reductions and costs NOx spreadsheet. Then we had NMED exhibit 4 amended, which was the amended ozone path forward plan that Mr. Baca testified to. We had the NMED rebuttal exhibit 24, which is the air quality control regions in New Mexico map that was included in Mr. Baca's Suhr rebuttal. And then we have the resumes of Mike Pring and Stephen Trumel, which are NMED rebuttal exhibits 30 and 31, which I had indicated we would put into the record based on Mr. Janot's cross-examination of Mr. Palmer. So I would just move admission of those exhibits.
All right, so NMED amended exhibit 4 and rebuttal exhibits 24 through 31 are admitted. All right, let's see, I have a query from Member Garcia about asking NMED another question. Member Garcia?
Can't hear you.
Can I? Oh, there. Okay, thanks. Sorry to make you go back to a technical question, but I just saw in my notes something I meant to ask yesterday and I forgot to ask. This would be a question for Ms. Keene. Under 117B3, the plunger lift, etc. I recall Mr. Davis, IPNM, and maybe NMOGA agreed that those items, they're agreeing to those items as long as they get moved to B1. And I'm unclear the difference. If you could explain to me, what's the difference in having them as number 3 by themselves or moved to B1? Would they not be enforceable? Would those 4 items not be required if they were put under B1? I'm not clear what the difference is.
Madam Garcia, I believe that their concern was that these are best management practices that should be utilized during the life of the well. and not specific types of technology that you should be used during a specific liquid unloading event. And we agreed to move those technologies under the definition of best management practices. They will be required to utilize one of those technologies. So it does not change the requirement fundamentally or change the enforceability of the requirement.
Great, thank you. That takes care of all my questions. Thank you so much. Appreciate you answering all the questions. You've done a fabulous job. Thank you.
Thank you, Member Garcia and Ms. Keen. Ms. Gutierrez, I see you on screen.
Yes, Madam Hearing Officer, I just, out of an abundance of caution, want to make sure I understand some of the exhibit entrances. As you know, EDF and Kinder Morgan filed a joint notice of filing of revised language. Would it be your preference, Madam Hearing Officer, that we refile that as exhibits respective to our previous filings?
No, thank you.
Okay.
No,
Okay.
thank you.
Thank you very much for clarity.
All right. Is there any reason not to move now into a discussion of the post-hearing process on our way to the board deliberations?
So, Madam Hearing Officer, there is still the issue of the NMOGA proffer on a couple of points, and I don't know if maybe we go through the rest of the post-hearing and then maybe we can get the board counsel on to talk about how she would like to handle that, or the two of you would like to handle that issue between us.
I'm
This
sorry.
this would be on the two spreadsheets and the excluded section of Mr. Smitherman's Suhr rebuttal.
So I guess I thought that the proffer had been made not this time, but the last time Mr. Smitherman was testifying.
Correct. And I guess I'm just trying to clarify with you and with her when we would get a ruling from the board so that we know their status.
Not until the beginning of the deliberations.
Okay.
As I understand Ms. Solaria, but there she is. I'll let her say it.
Right, I have nothing to add. I'm not clear what finer point has to be resolved today. I thought our decision was that they would take that up at the top of their deliberations at the time that was set.
I wasn't sure, Ms. Solaria, whether you were going to look at it then, or there's another board meeting, I think, between when those things might happen. So it depends a little bit about how you want me to cite stuff that might be in that section. And
right, I think maybe we might be putting the cart before the horse here. I think a discussion of the post-hearing submission and how the hearing officer wants that to work. We'll have that discussion, and then maybe we can slide back to this and see if there's anything specific to the proffer that needs to be addressed.
I think that makes a
And
lot.
timing wise, we would not be taking this up at the next board meeting.
Okay, thank you.
I see Professor Pasiniak on screen.
Madam Hearing Officer, similarly, I'm not 100% clear whether our exhibits were admitted because of the continuing objection. I believe when my co-counsel was talking about them, there was some discussion of that. It wasn't clear to us whether they were admitted. So I'd like to move to admit CCP and NAVA EP exhibits 1 through 5 and exhibit 8.
Thank you, Professor Pasiniak. I believe I might have said that they were admitted, but I'll say it again.
Thank you.
Thank you very much. All right, now is there any reason not to move to the post-hearing process? So let me describe how I've handled the post-hearing process for complex rulemakings in the past, and I'm happy to accept comment from anyone on this. It does typically take a matter of weeks after the end of a hearing, a long hearing, to get all of the transcripts in hand. Once the transcripts are in hand, the board administrator does forward them to the board members and board counsel. As to the parties, she sends what's called a notice of transcript filing. This isn't the transcripts, but it is a notice that she has, in fact, received all of the transcripts and has them in hand. And she won't send that until she has all 10 transcripts. Typically, from the date in which all transcripts are in hand, we set a deadline, and I like to put the deadline right on the face of the notice of transcript filing for post-hearing submissions by the parties. In a rulemaking, those post-hearing submissions would typically include closing arguments, which closing arguments would include also any legal argument that you would want to make on legal issues that have been raised. That's often contained in one document. And then proposed findings and conclusions that would become part of a statement of reasons. I know all of the lawyers involved know that it's imperative that this board, when they adopt whatever rule they're going to adopt, provide a very detailed explanation of why they're adopting each of the provisions. And that explanation, if you will, is called a statement of reasons, which would include findings of fact, or paragraphs that look like findings of fact, and paragraphs that look like conclusions of law. So the legal closing arguments, the proposed statement of reasons, and then what I found is one of the most helpful things to assist the board in their deliberations is effectively an exploded version of the rule and an explanation beneath each paragraph that you would support. Below each of those, citing to the evidence you believe supports that particular change. I know those of you who've been, for example, in the triennial review with me, Mr. Rose, Ms. Fox, you know exactly what I'm talking about. And by the way, I'm happy to send a sample of what that would look like to anyone who would like to see it. Then if you would send me that in Word, I would synthesize what the parties' recommendations are as to each of the provisions and provide a roadmap, if you will, for the board, again, without any kind of policy recommendations. Typically then on the front of that, I would have a very short hearing officer report that simply laid out the facts of the hearing, the fact that we had the hearing, a few comments about the platform, a brief summary of the sorts of public comments that we received, who the party representatives were, and the technical witnesses, and a recommendation. It's effectively a recommendation, at least a discussion of how I felt about the admissibility of some of the evidence. So all of that then gets bundled to the board. All the parties would be informed, in addition to the usual public notice, of the meeting of the board where they would deliberate. And of course, you would also be informed as to the result of those deliberations and provided with a copy of the order and statement of reasons. So I have a request here. Yeah, a sample of the rule revision description from Ms. Gutierrez. I'll just send everyone a copy of a sample so you can see what I'm talking about. Again, I haven't quite found anything else that is as helpful to the board during their deliberations as that document, because it allows them to spend time in one document in order to see every party's last best final proposal, instead of what they used to do, which was to have a post-hearing submittal from every party, and in this case that's a dozen parties, to have 12 documents open in front of them. We needed a dais that was about 40 feet long, so that every board member could have all of these documents in front of them to try to understand as they walk through the rule. So if I synthesize that, folks have, board members and commission members have actually been pretty enthusiastic about that document. So are there any questions from the parties about any of that? I know some of you know exactly what this looks like, but for some of you it might sound mysterious. Mr. Rose.
Yeah, I assume we'll talk about timing here too, but is it only the draft rule and explanations that you want in Word, or do you want other parts of the submittals in Word so that you can cut and paste in terms of putting your report together?
I typically just ask for that one sort of exploded document where you have cited to the evidence beneath each provision. I typically don't ask, for example, for the legal argument in Word. I'm not sure. It's usually just that one document.
Okay. And the other question is, since the board hasn't asked for a recommendation, I mean, at times we've provided, or at least I think you've provided, for the opportunity to comment or object to a hearing officer's report. But since you're not making a recommendation, I assume you're not looking at creating a timeline to do that either.
I guess I wouldn't include that in the timeline. Certainly, if I were to get something wrong, if I did not properly cut and paste from your post-hearing submittal, then I would want you to point that out so that the board knows about that. But again, I'm not making any recommendations around the substance of any of this petition. All right, so as to the timing, while I have you there, Mr. Rose, timelines following the receipt of the final transcript have ranged from 30 days to 45 days. This was a big rulemaking, but I'm wondering if you have a suggestion.
It was more a function of what it's going to take Cheryl to put the record together, or the transcript together, and get it to us. Since we're already in October, November and December get a little strange in terms of holidays. So it depends on, I mean, I would assume they got the transcript and the triennial together in, I think, about 2 weeks, and that was half as long as this. So I don't know whether we're looking at 3 or 4 weeks for a transcript, and if we're running into the end of October at that point. So 30 days would get us into Thanksgiving, and which is fine, or 45 days given, which is what we did for the triennial, probably makes more sense, although no great surprise, most of us will wait till the very end to do it anyway. So I don't know whether you give us 30 or 45 days, whether it's going to make that much difference, but I think with the holidays, 45 would make more sense.
All right, I agree with you. I was once asked by a paralegal whether they taught that in law school, to wait until the last day. Ms. Katz?
Oh, I was just going to say that I would greatly appreciate 45 days at least. Thank you.
Right. So 45 days after from the date that Pam has all 10 transcripts in hand, and sends all of you a notice of transcript filing. The date will be on the face of that notice, and we'll do 45 days and land on a business day instead of a holiday. Then I'm happy to take just 30 days for my part of it. And I think we need to make sure the board has everyone's post-hearing submittals and my report at least a couple of weeks before whatever meeting they would be taking this up at. So I'm not sure that we can identify exactly which meeting that will be now. Obviously, it'll be after the first of the year. I do know that the board, at least in the past, the board has not wanted to meet during the session, really. But perhaps I'll leave that to you, Madam Chair, to have that discussion with your board members. I don't think we should press the parties any further than 45 days, and I'd like 30 days, just because it's a lot of cutting and pasting. But if you, having heard that schedule, know, and I'm sure Ms. Deloria would advise you on this too, it's possible to set a special meeting and not just stick to whenever your regular meeting is. So, Ms. Deloria, anything to ask or add?
I was just going to add for the board's information for our final time constraint. Once the hearing officer's report is drafted, it's submitted to you all. That starts the clock on a 60-day window for you all to make the decision. So like we don't really, that's kind of a moving target right now, but I did want to give you that in terms of expectations.
That's helpful. Thank you, Ms. Deloria. So are there any other questions about the essential process? Member Garcia.
I think I'm unmuted, right? Thank you, Madam Hearing Officer, and I must commend you for doing a fabulous job with facilitating this hearing with all the technical challenges, being virtual, etc. It's been a very complicated hearing, and you did a really good job guiding us through it, so thank you. And I am so happy to hear you say that you would help facilitate the process of making decisions on the various interpretations of the rule that are being asked of us. I was already getting a headache thinking about how we were going to do that. So hearing you say that makes me feel a lot better. That's going to be a huge help. So thank you. And one other item. You know, your procedural order that you had in the beginning was very helpful to follow along and understand what's due when. So I'm wondering if it would, I just couldn't write fast enough. I'm wondering if it would be possible for you to write out some of these dates and timelines and things for us to know what's happening when. That would be very helpful.
I'd be happy to do that. Thank you.
Much.
Let's see, any other questions about the basic process? All right, we should probably look back to Mr. Heinzer's question. Mr. Heinzer, do you have a suggestion, or Ms. Deloria, do you have a suggestion for how Mr. Heinzer should handle, if you will, the excluded data?
I think it would be most appropriate to discuss the proffer in the post-hearing bundle. The board members would have access to that, and I still think it's, practically speaking, it would be best to just take that up for whenever they schedule deliberations. And in terms of scheduling, we would aim to schedule the deliberation early enough in the 60-day window that if there was a chance the board members wanted to reopen evidence based on what you've discussed with regard to your proffer, that we would have flexibility to do that. But I'm welcome to other suggestions. That's kind of where I've landed, having heard the hearing officer's preferred process.
I think that's fine. We can certainly address it at that point in time. What's in dispute now is essentially 2 Excel tables and 6 slides, of which I'm sorry, 7 slides. And so it's not a very big corpus of material. And what we could do is, in our filing, we could simply note that if we do cite anything that might be in the proffer, that this is proffer, and just make that clear. And then Madam Hearing Officer could sort of put that into a separate section or something like that, because it's just a pretty small little piece, and that might be the simplest way to do it. If that makes sense, because that would allow us to make our argument on the same schedule and not to cause any real delay to the board, I think, as it's moving forward.
Ms. Fox?
Thank you, Madam Hearing Officer. I don't think it's appropriate for a proffer to come in and you propose findings of fact and conclusions of law. That's really only for the evidence that's been admitted. And so maybe there's a middle ground here, but I don't think putting a proffer in proposed findings is proper.
That's fair for Ms. Fox. What we could do would be to put that in our argument on whether it should come in, would be to maybe include the additional proposed findings or other things in that, which would then be in that proffer package. And if the board were to decide to admit it, then they would have access to those additional findings of fact.
And so it'd be a separate document from your proposed findings, you're saying. I think that makes more sense. And then I think what we talked about is that there'd be, an opportunity for the department or whichever party wanted to respond to that material.
I think that should come in at the same time if possible, though. That otherwise will delay the board. But that's up to the hearing officer and the board.
All right. So I think you will have to make your arguments about the proffer in the post-hearing submittal. And again, the board will be taking this up at the beginning of their deliberations. Mr. Rose?
Yes, something similar in terms of my objections to the introduction of evidence. I said I was probably or most likely going to bring that before the board. At least at this juncture, I still plan to, although I'll take a look at that. If I do, my plan was to include it in my closing argument and then leave it up to the board. But since closing arguments are filed all at the same time by all of the parties, I didn't know if you wanted to have some iterative process for that or whether because we argued it. And I'll let folks know if we decide not to raise it so that, if they want to brief it, they certainly can, but not to include it if we decide to not bring that to the board. So that was the only question I had.
Yeah, I wouldn't really think that the board would want to lengthen this process with an iterative discussion about an evidentiary ruling. I think it would be very gracious of you to let the other parties know if you're not going to argue it. It'll save them a little time in their own closing arguments.
Yeah, I'll try to do that as hopefully before the transcript's filed so that folks will be on notice whether or not they're going to need to brief that or may want to.
All right. Well, thank you for that. Is there anything else that we can talk about while we're all together? There's a question from Member Bitzer and about, I guess, a potential interview, Member Bitzer. It may be that you want to raise that with board counsel.
Yeah, I'm not sure if this is an appropriate time to discuss this or not. I'm not sure how much longer today's meeting's going, but I've been approached by my hometown paper about doing a piece on what we're up to, why, what the implications are and so forth. And I don't know if that's I'm not an attorney, and I don't know if that's. I know lawyers are generally averse to trying their cases in the court of public opinion, but I'm not a lawyer, and I'm not trying a case. Although I've known a few attorneys who aren't so averse to that. But anyway, I just thought I'd throw it out there. I can certainly tell them no. It's not the Albuquerque Journal. I live in Corrales, so it's the Corrales comment.
Yeah, until the board acts, I think there are some dangers there, but Ms. Lauria?
I was just going to advise that we can speak offline about, I can advise you on that and we can discuss your concerns. I'm happy to do that, Member Bitzer.
Okay. And I wanted to let the rest of the board know that I've been asked to, in case any of them has any heartburn about me saying something. I'm also happy to run a draft by everybody if anybody wants to see it. I don't plan on taking any positions at this time in that piece. I just want to explain to my neighbors why I'm here and partly how I got here. like, why are you on this board? And anyway, so I thought we can have that conversation offline.
Thank you, Member Bitzer. Madam Chair?
Yes, thank you, Madam Hearing Officer. I just had a quick question. Hopefully it's quick about just the process. So I guess since you said we're all together and the board's here, so just so I'm clear as well, we will get all this information and at a future board meeting, when it's on our agenda, we will then identify the date that we will meet for deliberation. Is that correct?
Yeah, so it's not that 1-2 business where you have to decide at one meeting that you're going to deliberate at a subsequent meeting the way you do have to set a hearing that way.
Okay.
You would simply look at your upcoming agendas, consider, because you will be close to the session, consider whether you want to meet during the session and notice it up in the usual way. But the other part of that, apart from the Open Meetings Act requirements, publishing the agenda, putting it on the web page, etc., we would also specifically let the parties know that that was the meeting where you're going to deliberate. I'm sorry, Ms. Lauria, I see you on screen. Did you have something to add?
No, I have nothing further to add. I just wanted to be available for any further questions from the board on that point. And to that point, Roswina, if it works out better that we could schedule a special meeting for this, it's most likely would be a meeting specifically devoted to the deliberation. I would advise not having anything else on the agenda for that time. And as I mentioned previously, it's a moving target and we can certainly discuss the best date for that.
Okay.
Yeah,
Thank you so much for that. And go ahead, Member Honker.
Sorry, Chair. I was just going to say, I was going to suggest the same thing because it sounds like this could be a full day just deliberating on this.
Thank you, Member Honker. And I just wanted to take a moment, since we are still all together, to thank all of the councils, all of the witnesses, as well as all the public that came to provide testimony during these hearings. And of course, to my fellow board members and the support, your support, Madam Hearing Officer, Legal Counsel, Pam, and others that have helped guiding us through this process. And I also just want to reiterate that I really do appreciate on such a, I guess, a very high profile topic that I believe we all conducted ourselves with respect and within the process. So I really very much appreciate that. And we will continue to do our best to do that. And again, just thank you all. Appreciate it.
Thank you all. It's just been a uniformly excellent hearing with a high level of professionalism on everyone's part. Mr. Rose, I see you on screen.
Yeah, just one, and it's not clarification. I think that some of the folks who haven't appeared before the board may not know, but when the board deliberates, there won't be argument from council or any participation. We get to watch all of this happen without any way to intervene. So I just want to make sure folks are aware of that and prepared for it.
Thank you for mentioning that, Mr. Rose. I meant to mention that myself. It's all true. All right. We do have some public comment at 5, but we can break between now and 5. The event will remain open, and I'll be back. I'll be back at 5 to accept the comment. I didn't want to, say, oh well, we ended at 3. Too bad for you. So I will be back on the platform at 5 to accept public comment, and then I'll adjourn. So thank you all.